The supervisor's responsibility. The supervisor's responsibility. Supervisors and managers are held to a high standard of behavior. This is because they're placed in a position of authority by the employer and must not abuse that authority. Their actions can create liability for the employer without the employer having any opportunity to correct the harassment. They're required to report any harassment that's reported to them or which they observe. They're responsible for any harassment or discrimination that they should have known of with reasonable care and attention to the workplace for which they're responsible. They're expected to model appropriate workplace behavior. Mandatory reporting. Supervisors must report any harassment that they observe or know of, even if no one is objecting to the harassment. If a supervisor or manager receives a report of harassment or is otherwise aware of harassment, it must be promptly reported to the employer without exception, even if the supervisor or manager thinks the conduct is trivial, even if the harassed individual asks that it not be reported. Supervisors and managers will be subject to discipline for failing to report suspected sexual harassment or otherwise knowingly allowing sexual harassment to continue. Supervisors and managers will also be subject to discipline for engaging in any retaliation. What should I do if I'm harassed? We cannot stop harassment in the workplace unless management knows about the harassment. It's everyone's responsibility. You're encouraged to report harassment to a supervisor, manager, or another person designated by your employer to receive complaints, as outlined in our sexual harassment prevention policy, so the company can take action. Behavior does not need to be a violation of law in order to be a violation of company policy. We will provide you with a complaint form to report harassment and file complaints, but if you are more comfortable reporting verbally or in another manner, we are still required to follow the sexual harassment prevention policy by investigating the claims. If you believe that you've been subjected to sexual harassment, you're encouraged to complete the complaint form and submit it to the designated person at your company. This person can also explain how the complaint form can be submitted. You may also make reports verbally. Once you submit this form or otherwise report harassment, our company must follow its sexual harassment prevention policy and investigate any claims. You should report any behavior you experience or know about that is inappropriate, as described in this training, without worrying about whether or not it's unlawful harassment. Individuals who report or experience harassment should cooperate with management so a full and fair investigation can be conducted, and any necessary corrective action can be taken. If you report harassment to a manager or supervisor and receive an inappropriate response, such as being told to just ignore it, you may take your complaint to the next level as outlined in our policy under legal protections and external remedies. Finally, if you're not sure you want to pursue a complaint at the time of potential harassment, document the incident to ensure it stays fresh in your mind. What should I do if I witness sexual harassment? Anyone who witnesses or becomes aware of potential instances of sexual harassment should report it to a supervisor, manager, or designee. It can be uncomfortable and scary, but it's important to tell coworkers that's not okay when you're uncomfortable about harassment happening in front of you. It's unlawful for an employer to retaliate against you for reporting suspected sexual harassment or assisting in any investigation. Investigation and corrective action. Anyone who engages in sexual harassment or retaliation will be subject to remedial and/or disciplinary action, up to and including termination. Your company will investigate all reports of harassment, whether information was reported in verbal or written form. An investigation of any complaint should be commenced immediately and completed as soon as possible. The investigation will be kept confidential to the extent possible. Any employee may be required to cooperate as needed in an investigation of suspected sexual harassment. It is illegal for employees who participate in any investigation to be retaliated against. Investigation process. Our organization also has a duty to take appropriate steps to ensure that harassment will not occur in the future. Here's how we will investigate claims. A designated person or office will conduct an immediate review of the allegations and take any interim actions as appropriate. Relevant documents, emails, or phone records will be requested, preserved, and obtained. Interviews will be conducted with parties involved and witnesses. Investigation is documented as outlined in the sexual harassment policy. The individual who complained and the individual or individuals accused of sexual harassment are notified of final determination and that appropriate administrative action has been taken. Additional protections and remedies. New York State Division of Human Rights, or DHR. A complaint alleging violation of the human rights law may be filed either with DHR or in New York State Supreme Court. Complaints may be filed with DHR anytime within 1 year of the alleged sexual harassment. You do not need to have an attorney to file. If an individual did not file at DHR, they can sue directly in state court under the human rights law within 3 years of the alleged sexual harassment. An individual may not file with DHR if they've already filed a human rights law complaint in state court. For more information, visit www.dhr.ny.gov. United States Equal Employment Opportunity Commission, or EEOC. An individual can file a complaint with the EEOC anytime within 300 days from the alleged sexual harassment. You do not need to have an attorney to file. A complaint must be filed with the EEOC before you can file in federal court. For more information, visit www.eeoc.gov. Note, if an individual files an administrative complaint with DHR, DHR will automatically file the complaint with the EEOC to preserve the right to proceed in federal court. Local protections. Many localities enforce laws protecting individuals from sexual harassment and discrimination. You should contact the county, city, or town in which you live to find out if such a law exists. Harassment may constitute a crime if it involves things like physical touching, coerced physical confinement, or coerced sex acts. You should also contact the local police department. Other types of workplace harassment. Workplace harassment can be based on other things and is not just about gender or inappropriate sexual behavior in the workplace. Any harassment or discrimination based on a protected characteristic is prohibited in the workplace and may lead to disciplinary action against the perpetrator. Protected characteristics include age, race, creed, color, national origin, sexual orientation, military status, sex, disability, marital status, domestic violence victim status, gender identity, and criminal history. Much of the information presented in this training applies to all types of workplace harassment. Summary. After this training, all employees should understand what we've discussed, including how to recognize harassment as inappropriate workplace behavior, the nature of sexual harassment, that harassment because of any protected characteristic is prohibited, the reasons why workplace harassment is employment discrimination, that all harassment should be reported, that supervisors and managers have a special responsibility to report harassment. With this knowledge, all employees can achieve appropriate workplace behavior, avoid disciplinary action, know their rights, and feel secure that they're entitled to and can work in an atmosphere of respect for all people. Find the complaint form from the designated person at your company. For additional information, visit www.ny.gov/combating-sexual-harassment-workplace.